You're the beneficiary of a trust in California. You want to ensure that the distribution of trust assets is smooth and timely. So what are top 5 factors to keep in mind if you're the heir to an estate and are concerned about a bad trustee or possible trust litigation? Well, first comes the shock of disinheritance. It's traumatic, both at the emotional level and to a beneficiary's financial security. You've been wrongfully excluded from a trust. It's not what the trust maker would have wanted, and it's certainly not what you want. Your elderly parent or grandparent was isolated and exploited in order to change estate plans. It's important to retrace your steps and look back at the circumstances that led to you getting frozen out as a beneficiary of the trust. Undue influence is a more common phenomenon than many might think. Second comes stonewalling by the wrongdoer. When you realize you've been frozen out of a trust and denied distribution of assets, a common response by a rogue trustee will be to give you the silent treatment. They'll ignore you, expect you to forget they've committed breach of fiduciary duty, and pretend that you're going to go away. They're riding the gravy train, misappropriating trust assets. But you won't go away. You're a beneficiary whose rights to a trust have been violated. You're going to hold them accountable. Third concerns the persistent and rising threat of elder financial abuse. While awareness of the problem has grown in the media and society, so too has the rate of exploitation. Cases like these fall under the California Elder Abuse and Dependent Adult Civil Protection Act, which has proven a key weapon for advocates of abused elders and beneficiaries. This law enables victims to pursue civil litigation against wrongdoers with the option of a jury trial and compensatory damages. Fourth, battles over houses are becoming ever more common. With house prices remaining high in places like the Bay Area and Los Angeles, the family home becomes the object of conflict, up to and including lawsuits. Wrongdoing will typically occur when an ailing elder is unduly influenced to make a deathbed transfer of assets, leaving original beneficiaries frozen out. Sale of the house is the most viable path towards settlement between opposing sides. They can reach an agreement on how the proceeds of the sale will be split by percentage. Once the sale goes forward, each litigant can receive their payments via escrow. And fifth, trust mediation works. It's important to keep in mind that mediation in the state trust and elder financial abuse cases represents a well-treaded path to resolution. Out of all the civil litigation matters in California, only about 3% actually go to trial. The vast majority are resolved outside the courtroom through mediation or other settlement. If a rogue trustee or caregiver is stubborn enough, we'll be ready for litigation so that a judge or jury can decide. We represent beneficiaries across California, including in Los Angeles, Orange, Santa Clara, San Mateo, Alameda, Contra Costa, and Sacramento counties. No matter the venue or time, mediations will come with a context of emotional drama. The task of each party involved isn't to deny these emotions, but to focus on a practical resolution of the conflict so that each side can go home in peace with an equitable settlement reached. If you're a beneficiary who's been disinherited or you need someone to protect your rights, call us at Hackard Law, 916-313-3030. We'll be happy to speak with you. Thank you.